Good evening and welcome to Florida Criminal Law. My name is Stephen G. Cobb, and as you can see, today is Casual Friday. I don't have court, and we're going to do something a little different. We're going to be answering your questions because I'm really thrilled at the number of people who've been writing into our email, asking me questions, wanting to know more about my favorite subject, which is Florida criminal law. So let's get to some of those reader questions. And if you have questions, just drop us an email at info@cobblawfirm.com. All one word, info@cobblawfirm.com. So let's go over and take a look at the first question because I've got tons of them. A writer asked me and they wanted to know, how do I get a domestic violence no contact order dropped? Well, let me tell you how not to get a no contact order dropped. Contact a family member who then contacts the complaining witness. Contact the complaining witness directly. Take an aircraft, hire it, have it tow a banner a mile away that's visible from the complaining witness. Yeah, all of those things will get you arrested for violating a no contact order, so do not do them. Do not contact the complaining witness, who the state will call a victim, in any way whatsoever. What you do instead is you hire a competent legal team, and then the competent legal team can file what's known as a motion to change bond conditions. Now, this is much easier if the complaining witness doesn't want to prosecute. Does that mean the case goes away? Absolutely not. But what it does mean is you can use that information to help, while the case is pending, get the no contact order reduced and changed to a no violent contact order. What this basically means is that instead of the defendant being kicked out of their house, having to live with family, friends, or God forbid, in an expensive hotel for months and months while the case is pending, it's possible to do a motion for change of bond conditions, and a key component of that is if the complaining witness is helpful. Now, the way we do it is a little bit different than a lot of other law firms. A lot of law firms and lawyers want to do a dog and pony show to show you how hard they're working. I have this view that people care more about the results than, a show. So instead of doing it in a showy way, we try to get the complaining witness on board with a notarized statement, and then from there, I do a prosecutor call, or co-counsel does a prosecutor call, depending upon which one of us is the better person to do it, because I don't have to be a hero. I'm more concerned with getting things right for you. In other words, what is right is far more important than who is right or who gets the credit or anything else. The goal is to get you or your loved one home. And when you have a favorable complaining witness, that helps. Now, let me tell you how not to do it in another way. Don't expect the complaining witness to go to the prosecutor's office, make a request to drop charges, make a request to change bond conditions, because they're going to start loading up the complaining witness with all types of hoops to jump through, counseling to go through, etc., before they will agree to it. Why? Because they know that you don't know what you don't know, and they're going to use that to take advantage of you. So make sure that you hire competent counsel, preferably one that has a systemized approach using a litigation team, and then from there, they're going to do it one of two ways, with a stipulated or agreed upon motion to change bond conditions, or alternatively, by conducting a hearing if the prosecutor will not agree with it. So that's how you get a no contact order changed to no violent contact, which will enable the person charged to go back home.